Hello and welcome to the Ontario Human Rights Commission's webinar, From Exclusion to Inclusion, Planning and Human Rights. I'm Jacqueline Pegg, and I'm an inquiry analyst with the Ontario Human Rights Commission. I'd like to thank the Ontario Professional Planners Institute, the OPPI, for inviting us to speak to you today. The OHRC has been working with provincial and municipal governments, the OPPI, and planning schools on housing, human rights, and planning, and we're pleased to partner with the OPPI for today's presentation. Please note that OPPI members participating in this webinar may be eligible to claim learning units in OPPI's Continuous Professional Learning Program. Please go to ontarioplanners.ca for more information. Today I am joined by Loretta Ryan, MCIP, RPP, Director of Public Affairs and Policy for the OPPI. Okay, so today I'll talk about how planners and municipal decision makers can proactively plan for inclusion and avoid or remove land use planning related barriers to human rights with a focus on housing. There are 3 sections to this webinar. I'll start by setting out the legal, regulatory, and policy content, such as the provincial policy statement, social areas and grounds of discrimination covered by the Human Rights Code, how municipal powers must follow the code, and systemic discrimination. And then the last discussion point in this section is on the connections between the code, affordable housing, and planning. We'll then discuss removing barriers to human rights, such as discriminatory opposition, people zoning, and minimum separation distances. The final section of this webinar provides tools and tips for creating inclusive communities and sets out best practices. There will be time at the end for Q's and A's. Let's begin. The Universal Declaration of Human Rights and other United Nations documents recognize housing as a human right. In Canada, aspects of these rights are recognized through the Charter of Rights and Freedoms, provincial human rights codes, and a range of other provincial legislation and policies. Ontario's Human Rights Code, which I'll call the Code, is anti-discrimination legislation. The Code's preamble sets out human rights principles. These emphasize dignity, equal rights and opportunity, mutual understanding and respect, and inclusion. This creates an inclusive guiding vision for planning Ontario's cities, towns, and neighborhoods so that all residents can live in the community of their choice without discrimination. Under the Code, municipal staff and elected officials all have an obligation to make sure that people do not face discrimination and harassment in municipal processes and decision-making. The OHRC addresses some municipal obligations in its 2009 Policy on Human Rights and Rental Housing, and has since released 2 guides and other resources on municipal planning and licensing to provide more detail. These can be found on the OHRC's website. The last point here is that the Code has primacy over other laws and regulations. This means that if there appears to be a conflict, it prevails over other legislation, like the Planning Act, the Municipal Act, the Building Code, and so on. Before discussing code protections, I want to highlight provisions from the provincial policy statement that intersect with the goals of the Code. Under sections 1.1.1 and 1.4.3, municipalities are responsible for establishing and implementing minimum targets for housing that is affordable to low and mid-income households. This specifically includes second units, affordable housing, and housing for older persons, as well as improving accessibility and preventing and removing land use barriers for older persons and persons with disabilities, and permitting and facilitating all forms of residential intensification and housing to meet the social, health, and well-being needs of all current and future residents, including people with special needs. And Section 4.6 of the PPS reaffirms the legal obligation to follow the Human Rights Code and the Canadian Charter of Rights and Freedoms when making planning decisions. The PPS emphasizes that human rights are part of the public interest and that there's a responsibility to proactively plan for inclusion, remove barriers, and prevent discrimination. So let's move on to a discussion of the Code. Part 1 of the Code ensures that all Ontarians have the right to enjoy freedom from discrimination in 5 specific areas, which are called social areas. These are services, goods, and facilities, housing accommodation, contracts, employment, and vocational associations such as unions. The code also identifies 17 grounds on which discrimination is prohibited. These are disability, age and sex, gender identity and gender expression, sexual orientation, marital status and family status, race, color, and ancestry, ethnic origin, citizenship, and place of origin, creed, and receipt of public assistance in the area of housing, and record of offenses in the social area of employment. So where do municipalities fit under the code? Municipalities are providers and regulators of both housing and services that are essential to code-identified people and groups. They may also make contracts and are employers. Municipal powers relating to housing include zoning, licensing, public meetings, consultations, and other processes. So the question is, the Ontario Municipal Board hears land use planning disputes. It has the jurisdiction to apply the Human Rights Code. True or false? True. The OMB can apply the code and is an important forum for challenging planning decisions that have a discriminatory impact. It has made some key decisions relating to human rights in the past few years, which you can read about in our new Planning and Human Rights Legal Cases and Resources list, which will be up on the OHRC website later next week. So there are many forms of discrimination, and when talking about organizations like municipalities, it's important to consider systemic discrimination. Systemic discrimination can involve laws or policies, systems, practices, or behaviors that are part of the social or administrative structures of an organization or sector. These are discriminatory if they create or perpetuate a position of relative disadvantage for people identified by code grounds. It's important to know that under the code, it doesn't matter if you didn't intend to discriminate. To understand if discrimination happened, it's the impact on the person that matters. And sometimes the way we've always done things is the problem, and we need to change it. So what's the connection between the code, affordable housing, and planning? People who are identified by certain code grounds or combinations of code grounds, such as families, people with disabilities, young people such as students, people who receive public assistance, or newcomers or immigrants, are more likely to need affordable housing. So this can be lodging or boarding houses, group homes, supportive housing, social housing, other low-cost rental options, or even affordable owned housing. People who need this housing are disproportionately affected when planning, licensing, or other municipal actions either reduce the availability of existing affordable housing or put up barriers to new affordable housing. Some barriers are put up in response to discriminatory opposition. I'll address this and other barriers next. As I said, many groups identified by code grounds are more likely to require affordable housing. People are often opposed to affordable housing and certain services because they're afraid of a negative impact on their neighborhood. Their concern is often based on stereotypes and misinformation about the people who will live there or use the service. This commonly comes out as negative comments about people's assumed characteristics or behavior. It can also be hidden in unfounded or exaggerated claims about the impact the housing or service will have on the neighborhood, such as concerns about crime rates or property values. Not in my backyard opposition, often called NIMBYism, is a common response to projects ranging from industrial uses to casinos to high-rise condos to affordable housing. But when this opposition is based on stereotypes and misinformation about the people who will live in the affordable housing or use a certain kind of service, it has a far more serious impact than the usual opposition. It's a form of discrimination, which is often made worse when municipalities act or develop bylaws and regulations based on these unfounded concerns. Affordable housing is strongly in the public interest, and it's a stated and required provincial interest. But discriminatory opposition continues to limit and sometimes even derail affordable housing and much-needed services. Some discriminatory municipal bylaws and practices may be long-standing and may predate current interpretations of the Human Rights Code. But what was acceptable yesterday may no longer be acceptable today, and planning isn't unique in this respect. A home buyer doesn't need approval from neighbors to buy a home, and the same applies to people identified under the code who want to move into the neighborhood of their choice. Municipalities must not give the false impression that people have the right to pick and choose their neighbors. So people zoning is another human rights barrier. Section 34 of the Planning Act sets out powers of municipalities to zone for matters relating to land use. None relate to the characteristics of the people who will live there. Planners know that Section 35(2) of the Planning Act says that zoning bylaws may not distinguish between people who are related and unrelated, such as roommates or housemates, as opposed to a family. However, people zoning also includes distinguishing between residents based on other code grounds, such as age, receipt of public assistance, disability, addictions, and so on. You'll find key legal decisions on this issue in the new Legal Decisions and Resources list that we'll post soon on the Ontario Human Rights Commission's website. Even if code grounds aren't specifically named, planners and municipal decision makers must consider whether actions, bylaws, plans, zoning rules, or restrictions are based in discriminatory assumptions or have a discriminatory impact. Minimum separation distances, or MSDs, are another way we've seen planning result in discrimination against community members. MSDs may be fine for separating certain land uses, such as industrial buildings, livestock barns, or manure storage from residential areas. But they can't be used to distinguish between residential uses or limit or exclude people because of code grounds. MSDs also cannot be used to decentralize affordable housing. We've seen that they reduce housing options and they reduce access to services for people who identify by code grounds. MSDs often unfairly affect code groups. For example, municipalities commonly apply MSDs to limit group homes for people with disabilities. This is done regardless of the scale of the project or how it compares with other land use in the neighborhood. There are several recent legal cases that have resulted in municipalities removing zoning restrictions or being ordered to allow housing despite a minimum separation distance requirement. In 2013, a report from a human rights and planning expert hired by the City of Toronto found no planning justification for MSDs for group homes and recommended that they be removed. Over the past few years, Sarnia, Kitchener, Smith Falls, and Toronto all resolved Human Rights Tribunal complaints by removing MSDs and other zoning restrictions for group homes. So here are some more examples of planning barriers. Many of these appear motivated by discriminatory opposition, including red tape, like extra meetings beyond what's required by the Planning Act, unreasonable parking requirements, and design requirements or approvals that aren't required for other housing. These create an extra hurdle for the code-protected groups who need the housing, adding costs and delays and possibly preventing the housing. Also, public meetings that focus on biased, people-based comments instead of real land use issues are another barrier. Municipalities should avoid providing a platform for discriminatory comment and allowing affordable housing discussions to be derailed. Another barrier is miscategorizing housing, such as overbroad definitions of lodging houses or treating affordable housing as though it's a non-residential use. These things subject affordable housing to unjustifiable restrictions and reduce its availability. Some other common zoning barriers are limits on the number of affordable housing units allowed in an area, regardless of the density, planned use of the area, or intensification goals, and forcing affordable housing away from lower density areas to the periphery of residential areas, such as onto arterial roads. One way to know whether what you've been asked to consider is a human rights barrier is to ask this question. Is this policy based, even in part, on bias or assumptions about where certain people should live or what kind of housing certain people should live in. There is a concern that municipal licensing is sometimes being used as a way to people zone. True or false? True. In some municipalities, licensing is linked to exclusionary zoning bylaws or may otherwise target certain code groups or forms of affordable housing, which can be discriminatory. Municipalities have the right to license rental housing, but should only do it for legitimate purposes, such as to address genuine health and safety and property maintenance concerns. While municipal licensing is generally distinct from planning, in practice, licensing bylaws are often linked to zoning restrictions, and planners often wear several hats. It's important to consider linkages between planning and other municipal regulation. Municipalities can legitimately license rental housing, as well as business and services, such as methadone clinics. However, licensing often occurs in the context of discriminatory opposition. In fact, some requirements may drive up the cost of housing, impose unfair limits or conditions on residents and service users, or restrict or exclude important housing or services. Requirements should not be based on unfounded assumptions about risk, worst-case scenarios, or discriminatory opposition to rental housing or certain services. Like planning and zoning restrictions, discriminatory licensing can be challenged at the Human Rights Tribunal of Ontario and in the courts. It's important to avoid barriers from the start, and here are some ways to do that. Supportive housing, lodging houses, group homes, basement apartments, secondary suites, and other affordable housing. These are all residential uses. So while services may be attached to them, they are people's homes, not businesses or institutions. All forms of housing should be zoned as residential. Allow affordable housing options as of right, as long as they're consistent with the density and other land use considerations. And remove MSDs and other zoning limits to affordable housing in residential zones. Zoning restrictions only work to limit affordable housing. Instead, use incentives to encourage affordable housing, such as those set out in the MMAH Guide, Municipal Tools for Affordable Housing. Using these tools helps to increase the housing options and also to address factors that tend to centralize affordable housing, and it's less likely to run afoul of human rights law. In fact, the Supreme Court of Canada says that if a requirement discriminates, it can only be justified if it is based on legitimate goals, for example, health and safety, land use planning, and other municipal goals, not arbitrary or designed to exclude. If it's adopted in good faith, necessary to meet those legitimate goals, and if it's inclusive and accommodates differences to the point of undue hardship. So this is actually quite a high standard, and it's not an easy one to meet. Planners have told us many ways that they are making planning processes more open, accessible, and inclusive to better reflect community needs. Some of these practices include making sure the process is broadly accessible, both in terms of disability, but also other factors that may limit participation. For example, convenient and accessible locations and meeting times, informal and non-intimidating settings, and also how and where information is posted or distributed, and so on. Best practices also include researching the needs of the code groups who may be affected by a policy, bylaw, or decision, and reaching out to those people, both directly and through relevant community organizations, advocates, and experts. Then after a consultation, think about whose voices are missing. Identify gaps and do targeted research or consultation as needed. For example, in the affordable housing context, if you're hearing mainly from landlords, builders, or homeowners, but not from prospective tenants, then set up focus groups with people who can fill that gap. Taking all these steps will help you to act in the public interest and ensure that you address the concerns and needs of all people and communities who are affected by your decisions. For public meetings, there are several best practices. First, hold meetings only as required by the Planning Act. If zoning rules already allow the affordable housing as of right, a meeting isn't required. Holding extra meetings because of discriminatory opposition subjects code group residents to greater scrutiny than other residents and creates barriers to accessing housing in the neighborhood of choice. Here are some best practices that some municipalities use to appropriately handle public meetings. Set ground rules for discussion so that people can have their say about legitimate planning issues, such as location, size, setback, and parking requirements, but not use the meeting as a forum to express biased and discriminatory views. Make attendees aware that all community members have human rights in housing and services and their right to equal access to the neighborhood or area. Don't let discussion focus on assumptions or the characteristics or behavior of the prospective tenants or service users. You might need to enforce the ground rules by actively interrupting and addressing discriminatory comment, clarifying what the relevant planning issues are for discussion, and then redirecting the discussion back to those topics. And finally, if discriminatory opposition arises, it is important to address fears and misinformation with education and facts. Social science research helps to allay common concerns about affordable housing. For example, it shows that intended residents and service users are usually already part of the neighborhood. Research also shows that property values do not drop and crime rates do not rise because of affordable housing. Also, higher density can support more services, and that can benefit everyone in the area. And of course, the usual planning, design standards, regulations, and laws still apply. It's far better to prevent problems than to have to fix them later. So here are some best practices to help you prevent discrimination in planning. Planning discussions, reports, and decisions should focus on land use and legitimate planning and municipal goals, not on the people who will live in the housing, stereotypes or generalizations, or hypothetical impacts on the community. Here are 2 questions that planners and municipal decision makers should ask about any bylaw, decision, rule, action, or requirement. First, is its purpose to regulate people? Or will it negatively affect code groups? So here are some key ways to plan for inclusion. First, don't let planning be used to limit or exclude affordable housing or code groups from an area. Identify and remove barriers in existing plans, bylaws, and processes, and don't create new barriers. Don't let new zoning, licensing, and other regulatory schemes reduce available affordable and low-cost market housing. Positively promoting affordable housing throughout a municipality or region is more appropriate and effective than imposing MSDs and other zoning limitations. And plan with a broader public interest in mind. This means creating mixed-use communities that meet the needs of people who may be more vulnerable and less vocal in planning and other municipal processes. This creates safer, more inclusive communities for all. I'll wrap up this webinar by highlighting best practices for planning, and then we can take your questions. So, put into place a human rights lens to identify and remove barriers. Take steps to ensure an inclusive bylaw development process and non-discriminatory public meetings. And make sure that the focus is on land use, not on the people who will be living in housing or using a service. And finally, make sure that you consider the intent and impact on code groups, and that rules, bylaws, and requirements are genuine and justifiable. Taking these steps will help you to ensure that communities across Ontario are designed, planned, and zoned to include all people and to create environments where every person can feel truly at home. So we're now going to start the question and answer segment of the webinar, and I'll be joined by Loretta Ryan from the OPPI for this portion. So we'll start with a question that we've heard a number of times during presentations with planners, and I'll hand things over to Loretta.
Thanks. So the first question that we have is, transit access is important for affordable housing residents, and we have to plan to meet those needs. So why shouldn't we zone group homes or affordable housing on the periphery of residential neighborhoods or arterial roads closer to transit?
Yes, transit can be important for residents of affordable housing, but this is also true for all residents, regardless of whether they live in affordable housing. Also, some group home residents may not need transit, and in fact, many may have disabilities that may make it hard for them to take transit. And many affordable housing residents may need or prefer a quieter or lower traffic environment than they can get on the periphery of a residential area or an arterial road. So transit isn't a reason to exclude affordable housing residents from lower density or quieter residential streets. They're entitled to the same options and choices as others.
Okay, we have another one, and that's with regards to meetings beyond those required in the Planning Act. There's a trend for municipal councillors for all rezoning and other planning applications to get out in front of the public to discuss things. So there have been questions around that about, as you were saying, when to have these meetings and when it's appropriate.
Right, okay. So public meetings are very important in planning, but what the meetings are about really matters. So requiring meetings for affordable housing and not other housing implies that there's a land use difference between affordable and other housing, and that its residents aren't welcome or don't have the same right to live in a neighborhood. So requirements for such meetings can be a barrier because they delay the project. They can give neighbors the mistaken idea that they can approve or not approve the housing. And they can provide a platform for discriminatory comments and ideas. And doing this sends a subtle message that these are legitimate concerns. Okay, so are there any other questions?
Do you have some examples of some municipalities or some projects that you can think of where they got it right and where their approach was a success?
I don't have names of municipalities off the top of my head. I do recall I've certainly attended planning meetings where I felt, for example, that they were managed in appropriate ways so that when people were starting to make discriminatory comments, for example, about people who might live in a form of housing, that the people organizing the meeting sort of called them on it and sort of asked them to please address the sort of the planning issues at hand. There are municipalities, for example, who have been looking at rental housing licensing, but then became concerned about the impact the licensing scheme proposed would have on the availability of this much-needed sort of affordable rental housing, and decided instead to go with more enforcement of other bylaws, such as noise bylaws and parking bylaws, which were the concerns, community concerns upon which that whole licensing process was begun. So they sort of returned to, well, what are the actual problems? Let's address those problems rather than having this whole other scheme that may have a negative impact on the availability of that housing.
Well, thank you very much, Jacqueline, for sharing your expertise. This has been really helpful. And that's, before we go, we have a few things that we'd like to mention. You can see an address on your screen for a page on the OHRC's website where you can find the resources related to housing and planning, including guides on zoning and municipal licensing and a tip sheet. Also, as mentioned, the OHRC will be posting a new list of legal cases and resources later this week with web links to legal decisions, social science research, guides, and other materials. If you'd like to continue the discussion online, you can follow the OHRC on social media at facebook.com/THE_OHRC or tweet at them using the handle @ONHUMAN rights. You can keep up with the latest at OPPI by following us on Twitter @Ontario Planners, and don't forget to check out our new Planning Exchange blog available through ontarioplanners.ca. We've had great take-up on that blog, so I encourage you to check it out. We'll leave the webinar up for a few more minutes so that you have time to note the web addresses. And one last note, don't forget to put in your calendars the 2016 OPPI Symposium, Healthy Communities and Planning for the Public Realm. It's October 5th to 6th in Hamilton, and we're very excited. We've had some really incredible proposals put in. Thank you very much, and have a great day.